Well, here's the key to getting a severance package. First of all, there's no law out there that says anybody's entitled to severance. I don't care if you've worked 30, 40, 50 years. Nothing in the legal books gives you severance. Your rights to severance might be, however, embodied in a severance plan written by the company and expressed to employees. It could be in the employee handbook, although not likely. It could be a separate document that the company published expressing what their severance policy is, which probably then would be enforceable. No guarantee on that, but hopefully. So if there's something in writing that creates a severance right, or that talks about severance, expresses their severance plan, that's your first step. But let's assume there isn't. If there's nothing in writing, people will come and say, well, they've established a precedent because this person got 12 weeks and this person got 30 weeks. And so if they did it for these people, then I'm entitled to it too, aren't I? Case law is pretty clear that just because a company decides to offer one employee a severance package and decides not to offer another employee a severance package, if there's no severance plan stated, they have the legal right to do it because severance is discretionary. Look at it this way. When you get a severance, you have to sign a document waiving all your legal rights. You can't sue them after that. You're going to waive all your rights that you may have. So the key to getting a severance is to making the company at least acknowledge or believe that you have legal rights that could be advanced that they would have to defend if they didn't give you severance. That could be age discrimination or some other type of discrimination. That would be a legal right that you would then, of course, waive in exchange for so many weeks of severance. If it's not discrimination that would create leverage, maybe situations have arisen where you could have a claim for a retaliatory discharge because of something that you've done, which is considered protected conduct. Or maybe because you were out on workers' comp and then brought back and they didn't want you anymore, but they were afraid of a workers' comp retaliatory claim. They might offer you a severance on that basis. Often what you need to do when involved in a difficult work environment that becomes antagonistic is, number one, to make sure that you've hit them with at least some expression of you believe that you are a victim of legal discrimination, or that your legal rights are being violated, not just your moral rights or this is just unfair. So that they now believe, their general counsel and their human resources sit down and say, we don't want to have to defend a lawsuit by some lawyer someday. Let's offer them some severance and see if they'll sign off on that. So by getting offered severance, it normally means the company has some willingness to negotiate what would be essentially a full waiver of your rights. Also, though, of course, be aware that in severance agreements, the company puts in a lot of other provisions that need to be thoroughly read, such as covenants not to compete, covenants not to solicit. It could relate to a cooperation clause, non-defamatory clause. It could relate to many other provisions that they want to protect themselves down the road. So be aware that severance agreements come at a cost. It's giving something up in exchange for some money. The question is it enough for what you're giving up? You don't want to give up a year of your life, your work life, in exchange for 14 weeks of severance. So be aware that not only in a severance agreement do you waive your legal rights to sue them, you could be also committing yourself to conduct down the road. Typically, you want that severance agreement reviewed by a qualified attorney that can then make sure you're fully apprised that what you're getting, first of all, that what you're getting seems rational, that it makes sense, because you could be waiving other claims, bonus, commissions. You could be waiving your rights to being paid unfairly under the law that you may not even know about, that the lawyer could tell you, well, you have another claim that you haven't thought of here. So consulting with an attorney before you sign your John Hancock to the dotted line is an important thing to do. The attorney might be able to negotiate some more money for you, first of all, some additional weeks. Make sure you're going to get unemployment. Make sure you're not committing yourself to anything that you're going to regret down the road. And make sure that you're not missing anything regarding what in fact you are waiving. So that's the best way to approach that severance issue.